Good morning. It's April the 6th, 2016. Welcome to Real Estate Tips. I'm Wayne Russell, instructor, broker associate with RE/MAX Southwest, Sugar Land, Texas. Most of the information that we discuss comes from realtors, newspaper articles, magazines, and emails from different sources. The material provided here is for information purposes only. It is not intended and should not be considered as legal advice for your particular matter. Some of the things I'm going to cover today is the Code of Ethics, buyer's offers, option period, 1 to 4 family residential document checklist, Owelty lien, property damage prior to closing, square footage, agreement between brokers, and I cannot prove I'm entitled to that commission, in other words, procuring agent. Anyway, the top 3 Code of Ethics complaints last year, 2015, were the following. Number 1, Article 12. Many Article 12 complaints deal with Texas realtors who don't disclose the name of their firm or professional status as realtors. Number 2, Article 1. Often Article 1 complaints deal with Texas realtors who are not being honest or truthful. And number 3, Article 16. Article 16 complaints are frequently about Texas realtors contacting someone who has already an exclusive representation agreement with another realtor. In other words, you can't solicit somebody else's listings. So just be careful with it. That's the main complaints of 2015.
So the number 1 complaint was they didn't say who their firm was that they were with?
Right. Is that something?
Oh, that's kind of petty.
Anyway, is refusing to submit my buyer's offer an ethics violation? After submitting my buyer's offer for property, the listing agent told me she wasn't going to present the offer to her seller because she thought it was too low. I told the listing agent that it's a legitimate offer and you should leave it up to the sellers to decide how to proceed. Will she be in a violation code of ethics if she doesn't present my buyer's offer? And this probably happens from time to time. If she doesn't present the offer to the sellers due to her personal opinion instead of the seller's instructions, it's likely a hearing panel would find her in a violation of standards practice 1 through 6 of the Code of Ethics, which says the realtors shall submit offers and counteroffers objectively and as soon as possible. Anyway, I'll let you read the rest on your own.
Is it okay if your client says, I will not accept anything, don't bring me anything below
I understand
X?
that. I understand. And you know what, I would say that, we did have an offer of X. You want me to send it to you or what? And then just to cover you, to cover yourself. And I would. But,
yeah.
We do have an offer for $5,000, $10,000 less than what you said, but you want me to send it to you, or you want me to just reject it or what? So, I mean, just, that way you
Just
won't have
pose a question.
Yeah. Okay, does the fridge convey if it was only mentioned in MLS? A seller authorized me to advertise MLS that a refrigerator conveys with the sale. But when she sold her property, her contract didn't mention the refrigerator. In other words, they probably didn't have a non-realty addendum attached to the contract. And when she moved, the buyer said she should have left it since it was advertised as conveying in the sale of MLS listing. So I thought, MLS will probably supersede a contract. I'll tell you what, if you offer bonuses in MLS and you don't pay it, and the buyer's agent doesn't say anything about it, you're going to have to end up paying that bonus of X dollars in MLS, even though it's not listed in the contract. So make sure that the buyer can say you've offered it, and then they come in with a low offer, and you say, well, this doesn't include the bonus. So make sure that the buyer's agent waives that bonus. If not, you'll have to end up paying for it, because I've gone through that before. It says, no, if the signed contract does not say the refrigerator conveys with the property, the seller does not have to leave it. So in this scenario, you offer it, but you don't have to give it to them. So make sure you have a non-realty item addendum attached to it. Previous negotiation advertisements such as MLS aren't enforceable, like a contract signed by the parties. This situation is an example why agents should keep clients ensure of all material items or prior agreements are contained in the signed contract. The next is calculate. A lot of realtors say, well, when does the option period start? When does it end? So I want to go over this to you, how to calculate the last day of your client's option period. How do I determine the last day to terminate under my client's 10-day option period in the 1 to 4 family residential contract resale? Since paragraph 23, the termination option period uses the word within. So don't count the day of, count the next day for your first day. I'll go over it. Since paragraph 23, the termination option period uses the word within when describing the time period, day one of the option period is the day after the effective date of the contract. For example, if your client's effective date is January the 22nd, with a 10-day option period, the option period will end February the 1st. If your client wishes to terminate under the terminate option period paragraph, she must provide notice to the seller by 5 o'clock. You know, years ago, they didn't have a time frame. It could be 11:59. So right now, your option period ends at 5 o'clock, local time where the property is located. Next is what does an estate executor have to disclose to buyers? I want to go over this a little bit more in detail because I just saw an article in Sunday's Chronicle in regards to this situation. And I'm going to discuss the 11 exceptions, but then it appears that if you haven't lived in a house, that you don't have to have, if you're inherited some property, you don't have to have the seller's disclosure, but if you have lived in it prior, you do. I'm going to go over all that in just a second, so just bear with me. My client was named the executor of his mother's estate after she passed away, and now he's planning to sell the house she owned. He hasn't lived in the property, so he has no idea if there's any existing issues. Is he still required to submit the seller's disclosure notice to potential buyers? The answer is no. Certain types of sellers, like an administrator or executor of an estate, are not required to provide seller's disclosure notice to prospective buyers. So I want you to keep in mind, hasn't lived in the property, because I'm going to go over that a little bit more later on in regards to that article I had in Sunday's Chronicle. It says the seller should check the box 7B3 to show the seller's disclosure notice is not required. The situation is one of 11 exemptions found in the Texas Property Code statute regulating the seller's disclosure notice. Remember that even though this type of seller is not required to provide a seller's disclosure, he must disclose any known material defects. Now, this is a list. A lot of realtors have asked me, what are the 11 exceptions in regards to not providing a seller's disclosure, and these are the exceptions. Starting right in the middle of the page, the section does not apply to a transfer, pursuant to a court order, a foreclosure sale, bankruptcy, mortgagee by mortgagor or successors in interest, beneficiary of a deed of trust, foreclosure, fiduciary course of administration of decedent's estate, a co-owner, made to spouse or persons and persons a lineal line of consanguinity or one of more of the transfers. And that word means having a common ancestor. Between spouses resulting from the degree of dissolution of marriage, government entity, or new residence. A lot of times, you sell new construction, there's no seller's disclosure. And then the last one is the dwelling does not exceed 5% of the value. Somebody told me that they were listing a lot where they had a garage on there, and if it's only 5% or less than the value of the entire tract, then you may not have to provide a seller's disclosure. Like say, for instance, you're selling 100 acres and you have a small house on the property. It may not be valued at 3 or 4 or 5%, so you don't have to provide a seller's disclosure. And on the next page it says property condition item number 7B3, the seller is not required to furnish notice under Texas Property Code. This is the next one.
What about rental properties?
What?
You have to do seller's disclosures.
Okay, let's just say hypothetically you own 10 rentals.
Yeah.
You have to provide a seller's disclosure. It's not one of the 11 exceptions.
When you're selling.
Yeah, when you're selling.
Right.
Okay, you have to, right?
Yes, because it's not one of the 11 exceptions.
But you've never lived in them,
That's right.
so I should not have to.
But it's not part of the 11 exceptions.
You've owned it, you know.
So now, I've discussed 11 exceptions. Now, as I said, if you have, in the very beginning it said no if you haven't lived there. But in the Sunday's Chronicle,
Under the administrative.
yeah, it says right here on the next, on this article I got out of the newspaper, it says, my mom just died in Texas and I live in California. Our realtor sent us a seller's disclosure form to fill out. Our California attorney says not to fill it out as it creates a lot of liability for us. We haven't lived in the home for years. But apparently He did in the past. We haven't lived in the home or the house for years. Do we have to fill this out? Never ask a California attorney about Texas law. This is Chuck Jacobus. But anyway, it says, Texas state law requires that you fill it out. Apparently, if you haven't lived in it at all, but if you've lived in it some of the time, you're probably familiar with the house, even though it may be X years, according to this article, that you have to fill it out. It doesn't, if there's something you don't know, say so, you have to fill it out. When all else fails, tell the truth. Okay, next is a lot of realtors have asked me, you know, when I sell some property, what do I have to turn in? And if you're a listing agent, make sure you turn in your IABS, your information about brokerage services, your listing agreement, your seller's disclosure. They've got asterisks by HOA, mud, lead, and lead-based paint. Of course, if you're not in the HOA, then you wouldn't have it. If you're not in the mud, well, you wouldn't have it. Sometimes a lot of your areas in First Colony have been taken over by the city, so you won't have a mud anymore. But you would have a lid. And I use that addendum for the lid, and just go to the tax and you'll figure it out. The lid is your levee or your dam around the areas, and that, of course, this was all used to be pasture land out here, and to be able to develop it, they had to put retention ponds, detention ponds, and a levee. Lead-based paint if the house was built before '78 and MLS sold, and then if you're a buyer's agent, you need information about broker services, sales contract, third-party financing, broker notice to buyer tenant, and broker representation agreement. Now, I'll tell you what, some of the offices, you can probably turn in a contract like on new construction or whatever, and sometimes they don't require buyer's rep, but I like to have the buyer's rep, even if it's for a short period of time. Intermediary form, in case the only way you have an intermediary if one of you is representing the seller and the other agent is representing the buyer. Under the RE/MAX only RE/MAX Southwest. Another RE/MAX company, Coldwell Banker, that's not an intermediary relationship. If you're selling your own listing and you have a buyer's rep with a buyer, then that's an intermediary. But a lot of times realtors will just say to the buyer, they just have information about broker services and notice the buyer tenant that I'm going to represent the seller. I'll treat you honestly and fairly according to my code of ethics. You want the house. So you don't have an intermediary relationship. You just have, you know, you're representing the seller only. So there's no intermediary. You don't have to have a paper signed unless you have a buyer's rep signed by the buyer. If you don't have a buyer's rep signed, that buyer is a customer, not a client. Okay, and then of course, if you're a selling agent, you turn in this paperwork here, a buyer's rep, and an intermediary form if it's a listing with RE/MAX Southwest, your commission worksheet, your CDA, your copy of commission check, closing statement. And I like to have for your files too, in case they want it afterwards, but I'd keep your inspection report and home warranty. And I think the home warranty is real important when you're listing and provide a home warranty because it affects your E&O insurance, your deductible. So that's one of the requirements. If you provide a home warranty, that you can, your E&O insurance will be less than. And if you're in the lease situation, if someone wants to lease some property and you need to turn in some information to the office to get paid, these are the things you need. The information about brokerage services, executed lease, right to lease, agreement between brokers, and MLS closeout. Of course, as you noticed in the previous column, or I talked about agreement between brokers, you don't have to have it filled out, but I like to have it filled out, and it's because it spells out if there's any bonuses on renewals or the commission if the tenant decides to buy the house. So I like to have it filled out. And then if you're the selling agent, information about broker services, residential lease application, authorization to release information, broker notice to buyer tenant, executed lease agreement between brokers, and a copy of the commission check. And then on the information about broker services, a lot of us, I've talked to several realtors, and they still don't know how to fill out the IABS. But this is how you fill it out. If you're independent and you're not with a group, like say Bill or KC or Mary or something, let's just say you're on your own. So it's really obvious, you don't have to have the buyer, seller sign the information about broker services, it's only initials. So at the bottom, if you're by yourself, you put Remax Southwest on the top line and Jennifer Wang on the second line. And on the fourth line, you put your name. Now, the only difference if you're with a group, like, as I said, Casey or Bill or Mary, you put whoever is your supervisor there. I assume that Casey would be in one group, but Mary, I don't know, her daughter may be the supervisor. I don't know what a relationship that there is, but if you're with a group, that supervisor's name goes on the third line. And if you're not, you just have, your name goes on the fourth line, either way. The next one is, I'm buying my husband interest in our house as a part of our divorce. I'm buying a title insurance for the lender. Nobody seems to know what's going on. Why is this so complicated? When you buy your husband's 1/2 interest, you can only put a lien on that 1/2 interest. Most lenders don't want that. The exception to the rule is the unusual Texas product called Owelty lien, which when you purchase that 1/2 interest, the lien encumbers the whole property. It requires special documentation. It's probably taken a little extra time for the title company to process. However, it shouldn't be a problem. So I mean, that happens from time to time.
Can't you just do a quick claim deed? They're pretty sure there's no liens against it, and get a name off of it?
Well, this is with a lien. So when you have an existing lien on your residence and you get divorced and you're gonna buy out your spouse, then you'll have this special lien. So anyway, I just want to bring it to your attention. But if you have no liens, then I'd still get a deed from your spouse, not quick claim, I'd go with special warranty, or general if you can. But a quick claim is not as strong as a special. Just like on foreclosures, the banks give you a special warranty deed, and let's just say they've given you a lien for 30 years, and you've owned it for 10 years, then they only warrant the time they own it at foreclosure day. They won't go back 5 years, they only warrant the time they foreclose on that date till today. So it could be 30 days, could be 6 months. So anyway, the definition of that Owelty lien is the amount paid or secured by one owner to another to equalize a partition of the property in kind, a payment made to achieve equality between those who exchange the property. Now, the property was damaged before it's, it could be a fire or something. In other words, before it was supposed to close. Last year, Texas experienced severe weather events, including flooding and tornadoes that caused damages to their properties. These and other perils can also affect the real estate transactions that haven't closed. The Casualty Loss paragraph 14 of 1 to 4 family residential contract resale requires the seller to restore the property to its previous condition by closing. If the seller can't buy, the buyer has three, but if the seller can't, the buyer has 3 options: terminate the contract, extend the time, or accept the property. It says, accept the property in its damaged state with assignment of insurance proceeds if permitted by the seller's insurance carrier. The seller also credits the buyer the amount of insurance deductible at closing. And if, however, the buyer cannot cancel the contract without giving the seller the opportunity to remedy the situation. If I was a seller and my house was damaged, I'd go that route. Because you may have a problem if you hire a contractor to make the improvements and the buyer doesn't like it, and you just end up with a problem. Anyway, however, the buyer cannot cancel the contract without giving the seller the opportunity to remedy the situation. If she attempts to do so, she would likely forfeit her earnest money and could be subject to specific performance provision of the contract. The contract does not address situations in which the parties disagree whether the property has been restored to its prior condition. If a dispute arises, that the determination could be made through mediation or in court.
Doesn't it need to be done within the contract time period?
That's a good question. You may have to extend. See, that's one of the things here. It says extend the time after the closing.
But if they don't want to extend it, then they may not have to.
Well,
Purchase it back.
right, right. So you might as well buyer just he has the right to terminate the contract.
But he doesn't get his earnest money back.
He does.
Oh, yes.
Earnest money,
Yes.
not option
Number
money.
one.
Not option money.
He gets the earnest money back.
Not the option, like the option
Right,
period expired.
right. Option money, that's why I like a lot of option money rather than a lot of earnest money. Anyway, this is the paragraph 14 of 1 to 4 family, where it says casualty loss. The next one is how to report square footage. In other words, I've gone to listings, appointments, and the owner goes, well, I have 3,000 square foot, and the tax roll says 2,500. Well, when you start calculating your CMA, you usually do it on so much a square foot times square foot, and you come up with a value, and then the owner goes, well, no, that's not right, because I have 500 more square foot. So anyway, how to report square footage. I represent a seller whose existing survey has one number for the square footage, while the appraisal district has another number. How should I report this to potential buyers? If you list the square footage of the property, you should always quote the information source and let the prospective buyers know if you have any reason to know the information is false or inaccurate. Most of the time it comes from the central appraisal district. You know, when you pull up the taxes, it'll show, you know, pull up the tax information, it usually shows the square footage. And I think most owners put in there, or most listing agents put in the square footage from that source. Use the notice of information from other sources, TAR 2502, to report this information. And I just happen to have it. If there's a problem, here's a notice of information from other sources. But you know what I've never seen is on any listing under docs or anything when I'm showing listings. So sometimes they'll put from the tax information or from the seller. If the seller quotes something, you can use that source, and you can put that in MLS. Is an agreement between brokers for residential lease required for MLS offers or compensation? I listed a rental property in MLS and offered compensation to other MLS participants. Another broker who is an MLS participant saw my listing and submitted her client's lease application to me. After the landlord accepted her client's application and executed lease, the broker told me I must sign the agreement between brokers for residential leases. He should have sent this to them in the very beginning, along with the notice to buyer tenant, but anyway. Do I have to sign the agreement? Well, you know, that agreement specifies how much you're going to get, even though the MLS states what you get. The notice to, it's just a little bit more, that you get 50% or whatever it is of the commission of the lease, and then 50% maybe of any renewals, and then say 50% or 3% of the purchase closing costs. But you don't have to sign. It says no, an offer of compensation in the MLS becomes enforceable when the corporate broker is procuring costs. In other words, the MLS will take care of that. But I really prefer the notice to be signed by the listing agent and myself to spell out renewals. Now let's just say you got the agreement between brokers and you put in there that you get 50% of the renewals. And so 12 months later, the tenant renews for another year. And the listing agent and the owner goes, fine, you know, so then you're in touch with the tenant, and the tenant goes, oh, I renewed the lease for a year. Oh, you did? You have that notice to buyer, you know, between the brokers saying, where's my money? You owe it to
The
you.
owner would be responsible?
If the owner,
Something.
the agent / owner is responsible. Now, let's just say I'm the owner. I didn't sign the agreement between brokers. And my broker didn't tell me that I was supposed to pay a 0.5% or half a month for a renewal. You're gonna pay, the agent. And I've had that come up. And so I've, you know, so I mean, prepare these documents and agreements in your favor to see what will transpire. Now, some agents, listing agents, are pretty quick, and they'll just mark through there. Or the buyers and the seller's not going to sell. They'll even mark through the commission. I'm not going to pay any renewals. So I mean, but if they leave it alone, you're going to get some more money if the tenant renews for another year. Okay, some brokers found the agreement between brokers and residential leases TAR 2002 beneficial since it specifies time frame for payment, covers compensation for lease renewals and sales. Still, an agreement between brokers is not required to enforce the offer of compensation specified in MLS. And I just happen to have agreement between brokers for residential leases. And if you never filled one out, well, I just filled it out for you. I've got the property, which is the address, the landlord and the tenant. And I got 50% or whatever y'all, there's agreement in. So, you know, I would say majority of the time it's A1. There might be a certain situation.
Have you ever been with the broker to sign one of these like this?
What?
They ever sign it?
Well, the listing agent and the buyer's agent or other agent needs to sign it.
As other or the buyer's
Yeah,
agent?
you're the if you're the listing agent,
Oh, no, didn't sign that.
right? But let's just say you got the listing, and I'm the other agent, and I'll right. And so it depends. A lot of agents will mark through there, and some agents won't. So if you're the other agent, make sure I drew it in the favor of me if I'm representing the tenant. And other fees, renewals, 50% of the first month's rent. Sometimes the other agent will mark through that. And sales price, sometimes they're not intended on selling, so they may mark through that. So, but you know, prepare these documents in your favor and see what happens. And don't forget to sign it. Okay, how can I prove I'm entitled to that commission? My buyer visits the property without me. Sometimes your buyers will call the sign and say, hey, I want to go look at the property. Can you meet me over there?
Or they call the listing agent after.
Well, sometimes, right, and sometimes they'll just call the listing agent because you know, it's convenient. You're out of town and they go look at the
Or
property.
you show it and they'll go back behind you and call them direct.
Right, so that's why you have to have, you know, if you have information about brokerage services and notice the buyer and tenant, they're not your client. But a buyer's rep protects you because it states in there how much you're going to get compensated. So that's why I like a buyer's rep, even if it's for 30 days.
Even if you have that, it doesn't have, they can cheat you.
Well, you can sue them. And there was a
No
suit.
time.
Oh.
No
I
money.
understand that. There was a suit filed close in for that the person went into an office and the agent got him to sign a 1-year buyer's rep, but then forgot about it. And so that person went around looking at different places and ended up buying it. So the company sued the buyer. But when they went to court, they said that, well, you didn't follow through, you didn't stay in touch with me, you didn't do this, you didn't do that. And so they sued for commission and got zero. So to an effect, the buyer's rep, you could say, is useless, but I just think that it's just more protection for you if you can get it signed. Anyway, my buyer visited the property without me, where the listing broker showed the property to my buyer. The next morning, the buyer had me write an offer for the property. When I presented the offer to the listing broker, he said that I wasn't entitled to a commission because he was one who showed the property to my buyer. Is the listing broker correct? The answer to this question hinges on who is the procuring cause of the sale. And it will be up to the arbitration panel to make the final determination if there's a procuring cause dispute. Procuring cause is defined as an uninterrupted series of casual events which results in a successful transaction, a sale that closes. NAR provides an extension list of specific factors an arbitration panel should consider in such disputes. Here are the few of these factors: the nature and status of the transaction, the nature, status, and terms of the listing agreement, offer to compensate, the role and relationship. By the way, when you're showing properties and the compensation is 1%, you might get lost on the way to that property. So make sure that when you start showing properties that you're going to get compensated and look for bonuses. Okay, so and make sure you get 3%. And so, anyway, I know one of the agents in the office thought they were going to get 5%. Well, it had 0.5. And he says, hey, Wayne, I'm going to get 5% commission. I said, no, you're not. Say it was $100,000, and 5% would be $5,000. He said, I'm going to get 5%. And I said, no, you're not. He says, well, there it is right there. And I says, well, look at the decimal point. You're going to get a half a point, $500 for every 100,000. Well, he called the builder and he said, yeah, we're offering a half a point. Well, he was showing the property, there was a train in the way, and he got lost, couldn't find the house. That was a joke. The roles and relationship of the parties, the initial contact with the purchaser, who first introduced the buyer to the property, the conduct of the broker agent, continuity and breaks in continuity, the conduct of the buyer. Is a question above, the listing broker showed the property, however, the arbitration panel will consider numerous factors like those listed above to determine the procuring cause of the sale. Now, I've gone over this several times in the past about closing costs, but I want to make sure you understand this. This is about the third time. Now, let's just say you went out and got a listing on the property for $100,000, and you closed in the middle of the year, and the tax rate is 3%. On $100,000, so the tax proration would be $1,500. Y'all understand that? Now, if it closes in January, the tax proration is less. If you close in December, say the 30th, the tax proration would be 3% of 3. This would be $3,000. So I've got it broken down here on a $100,000 sale. The compensation to a realtor is 6%, say $6,000. And the monthly payment is say they've got a monthly payment of $1,000. But most of that, if it's a 30-year amortization, most of that, let's just say they bought it last year, would be interest. So, and let the title company make the payment. Don't let the seller make the payment, because sometimes those checks are in transit, and by the time you close, you'll eventually get credit, but you may have to wait 2 or 3 weeks. So let the title company pay it unless it goes past 5 days after the first of the month, so you won't be a delinquent. But try to let the title company make the payment. Now, I've got monthly payment, I got tax proration. If the tax rate is 3% of $100,000, it closes on June the 30th, the tax proration is $1,500. Title policies usually run about 1% around 100. But I went back and showed you the tax table last section. Then the cutoff is $57,500. If 1% of $57,500, if it goes less then the percentage is higher. If it goes more, then the percentage is a little less. So at about 100, it runs about $900. So it's about .09 or something like that. But anyway, I'll just average it out. And the tax proration, you got your miscellaneous closing cost and note balance. So let's just say you owe $80,000, so you walk out with the title company of $10,000. And if you owe $90,000, then you walk out of the title company with 0. And don't forget now, this does not include sellers paying purchasers' closing cost. And it doesn't include any repairs. Now, I've already gone over foundation fees, but foundation fees are in Riverstone and Sienna Plantation. So it doesn't include that either. Let's just say it's a $300,000 sale, and the foundation fee is a half a point in Sienna. It's $1,500. I didn't put that in here. And in the Riverstone, it's a quarter of a point plus a cap fee on the buying side. So some subdivisions have cap fees, and I always go by Riverstone, but some other subdivisions have cap fees, and you may not be aware of it. So if you do have a buyer and you go on the MLS and sees the phone number for the HOA, you might give them a call. Because if you don't, the buyer may ask you for that cap fee.
Right.
I'm not looking at anyone.
Okay.
Anyway, does not include foundation fees, community enhancement fees, which is the same thing. Certificate of compliance, resale certificates, transfer fees, credit on HOA, mortgage escrow, and title escrow fee. Now, there's a difference between mortgage escrow, when you have PITI, when you close, you get those monies back 2 to 3 weeks after closing. There's also a title escrow fee. Now, title escrow fee is charged by the title company. And the last one I looked at was about $400. So, I mean, that's in addition to the title policy. Now, in essence, if you close in the middle of the year and you commission 6%, your closing costs for the seller will be 10%. Now, let's just say you close in the middle of the year and the person doesn't owe any money, it'll run about 9. Because you don't have any interest proration, you don't have monthly payment. So, pretty close to that. I've got all these numbers time after time. Let's just say you close in January on a loan, it's 9%, in June, it's 10%, and at the end of the year, it's probably gonna be 11. And if you don't have a loan, it's probably gonna be about 8% in January, 9% in June, and 10% in December, depending on when you close in the year. Now, let's just say you're gonna buy a home, and someone asks you, well, what does it cost to buy a home? Well, the sales price is $100,000, the down payment is $5,000, your closing costs run you about $5,000, so you have a $95,000 lien. And it does not include cap fees. But anyway, the down payment and closing costs approximately 10% on a conventional loan. FHA is about 3.5 plus your closing costs, and your VA is 0 down plus your closing costs. And then, of course, the VA could get into a house with nothing down if you have the seller pay the closing costs. Anyway, and then when you go get a listing, and I know you have 20 listings, but these are the things that you want to send the buyer to see if they're motivated, if they're really going to list with you, or if they're going to just use you as information of what, you know, I think my house is worth because I'm going to list my house with Cousin Jane, or I'm going to try to sell my house by myself. If you can give them a list of things to do, they're probably motivated to list with you. If you don't get that listing that day or that night, you probably won't get it. So these are the things you tell the seller to give to you. I've gone over this once before. Seller needs to provide the following: the homeowners association phone number and monthly and annual dues. A lot of times you have 2 HOAs. Like in Grants Lake, you have 2 HOAs, but most of them have 1 HOA. Now, there are 2 in certain parts of Riverstone. Those 0 lot line homes, they have 2 HOAs. Okay, then the mortgage information, the loan balance, the monthly payment, extra key for the lockbox, copy of the survey, any warranties, list of any updates, list of utilities, trash pickup or any pest control contracts, phone numbers and monthly charges, security codes, and copies of any inspection in the last 3 years. Now, if the seller's willing to give you and provide you with that information, you send them an email or send them a hard copy or snail mail, or to make sure that they understand you need this information so that you can service their account, because you just be in the dark on these things. So I think it's best for you to send this information to prospective seller so that they'll have that for you. And if they don't have that in front of them, and they don't have a key for the lockbox, they're probably not too motivated. They're just maybe using you to protest values or using you to list with Cousin Jane. Okay, now let's just say you're working with a buyer. I got this information from 2 different sources. This is the tail end of my little deal here. But if you're working with a buyer and you're working with a certain mortgage company, you need to, these are the things that you probably need to provide to the mortgage broker or the loan officer. Copy of your current ID, 2 pay stubs, 2 consecutive bank statements, W-2s for the last 2 years, 2 tax returns, and your insurance agent, an executed copy of your purchase agreement, and copy of the earnest money check, the canceled earnest money check. They'll need this information. So it's, you know, you just don't walk in and get a loan, you have to provide this information. And another insurance company, I got this, of course, identification is required, and you need to list your assets, your bank statements, your IRA, your 401, your stocks and bonds, the lease agreement if you have an existing lease. And by the way, if you're showing buyers properties, ask them if they're in the lease. Say, oh yeah, I just signed a 1-year lease. I just want to go for a ride and look around. Well, try to work with buyers where their lease is ending here sooner. Because if they just sign a 1-year lease, well then you might be wasting your time. Income, W-2s or 1099s, pay stubs, Social Security and pension award letter, personal and business, federal income tax, Of course, you have to get an appraisal, after this, but mortgage verification, survey, refinancing, property taxes, hazard insurance, or homeowner's insurance agent, and then miscellaneous, your DD 214 for VA loans, final judgment, credit issues, bankruptcy papers, and copy of canceled earnest money check. And they want the front and back. And then these are the things that you should do, and some of the things you not do when you're getting a loan. Keep detailed documentation of deposits transferred over $500. Keep all bank statements and documents at large deposits. Bring letter of explanation of any job gaps. Respond quickly to information requested on your loan. Contact the title company 24 to 48 hours prior to your closing to get the exact dollar amount so you can bring them in a cashier's check. And then things not to do. Sign a long-term lease extension. Change jobs. Incur additional debt. In other words, don't go out, tell your buyer, don't go out and buy a bunch of furniture and stuff because it could affect the loan. It says leave town the week of closing without making arrangements for a power of attorney. Apply several lending institutions concurrently. Do not plan movers or installation of blinds, etc. services until closing. So anyway, any questions? I sure do thank you for coming. I hope y'all learned just one thing, and y'all have a great day, and I'll see you next month.